Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman.
Thanks so much, Michael.
Now, before we start to give you some more information about our trip to India, what discussions we had with the consular officers, what is the latest information, and many other things, I think David wants to talk something about H-1B program.
Yes, actually, Michael, I just wanted to remind our viewers that the H-1B season now for CAP cases is in full swing. We started applying for H-1Bs, petitioning for H-1Bs on April 1st, and we're looking at CAP cases for an October 1st start date. And we remind our viewers to take careful heed of the fact that some of these cases are CAP exempt. So obviously, you can start immediately if it's a CAP exempt case. What are CAP exempt cases? Well, CAP exempt cases are, number one, if you are doing a transfer, you're not subject to the CAP. We get a lot of calls and a lot of questions from our viewers. If you already have an H-1B and you're transferring your H-1B, it's not subject to the CAP. If you're going to work for an academic institution or an organization that's affiliated with an academic institution, it's not subject to the CAP.
I think David is making a very good point, because some people are thinking like this. In the last year, the visa numbers, I think, went up to end of July or August.
No, there were H-1Bs until November.
November.
Yeah.
So people are thinking, what's the rush? I believe that this year it's going to get over much earlier.
Well, they're going faster.
They're not going to be November.
They're going faster, Michael, and the projection is that we're looking at running out of H-1Bs, CAP cases, by August or September. So,
therefore, it is extremely important. If you are planning, please do it now as soon as possible. It's not predictable. Even that prediction of August, September may not be there. Who knows? There all of a sudden there may be a big surge in the applications. They may go early. But if you want to do it right away. There's no reason to wait.
And as an aside on that, Michael, I think it's really important to point out to our viewers, because a lot of people ask me, what do you make of the fact that these H-1Bs are being taken up quicker than last year? I mean, the H-1B initial application pool was double what it was last year. So what does that tell me? Well, I take a step backward. I tend not to look at the stock market, although the stock market seems to be doing well, as an economic indicator. What I do is I always look at the H-1Bs as an economic indicator, because it tells us what's going to happen in the fall. And obviously employers are gearing up for successful projects and investment in their own economic infrastructure, which I think is, obviously you can see it happening by virtue of the fact that more H-1B visas are being taken up than last year.
David, when you are talking about H-1B visas, I'm thinking about some of my poor H-4 clients who went and applied for H-4 visa at the American consulates and had a hard time. Some of them are held up still about giving the papers of the principal H-1 and other company or some other issues. If you recall, we had a lot of discussions almost with every post on this subject. Why don't you tell the people what we spoke, what we discussed, and how they are looking at H-4 applicants?
It was very interesting, Michael, about H-4 applicants. We did, in fact, we raised it in Chennai, we raised it in Mumbai, we raised it in New Delhi, and we were interested in the council's view on the H-4. But by way of background, explaining it a little more clearer for our viewers, what it is that when a person goes back who has an H-4 and they're seeking the H-4 stamp, what the consulate is doing is putting that case under administrative processing and requesting that the individual have the H-1, the primary H-1, come back to India so that they can examine the case. Now, our issue, of course, is, well, that's not what the case was about, because the H-1 case is not under review. The H-4 case is the case under review. Now, the consular officers take the position.
The H-4 husband, for example, is in his status, is working, getting the same salary as per the petition. Everything is okay.
That's right.
H-4 is a wife, for example, and children. At that time, what we both discussed with them, that at that time, the only issue should be, is this a real husband and wife, the real children, exactly. And they are derivative. They are riding in a piggyback on the shoulder of the H-1. Now, What are you doing with the H1? You cannot do anything without H1. You are holding the H4 for what purpose? You're not going to be able to then the petition that you can return to immigration and get a review of that.
Right.
So based upon that, I think we heard their comments. You can talk more of the comments.
Well, we heard their comments loud and clear, and
Yes.
the consular officers, in general, their position was, well, no problem, send the person back, and we'll interview them, and then we'll make our determination. And their feeling was that they had the right to question the validity of the underlying H-1B through the application of the H-4 for the stamp, because they had a question as to whether or not that underlying H-1B is or is not valid. Now, that means probably that there must have been some concern by the U.S. consular official with regard to possibly the individual being paid the federally mandated prevailing wage, whether or not that was in fact the case, whether or not the individual was working at one of the sites, which may be a site that was not listed on the H-1B application, or maybe there was some other defect. For example, as we know, maybe a complaint was lodged with the U.S. Department of Labor, and the U.S. Department of Labor now is freely speaking to the U.S. Department of State, and there may have been some communication back to the U.S. Department of State which raised a particular issue, and they are then looking at the underlying H-1B and doing it through the H-4 case.
Also, I think one or two of the consular officers were saying that there may be a problem with the employer also. For example, they have information this employer has been maybe doing fraudulent petitions or not complying with the law, or there are complaints already under investigation of that employer, then they want to look into that aspect. If what the point was that if H1 is not supposed to have gotten this H1 visa, he got his H1 by fraud or misrepresentation either from the employer side or from the alien side, then they say he's not in a valid status. Correct. So if he's not in a valid status, why would we give to the wife to go and join him? This is one theory. Right. I mean, we may or may not necessarily agree with it. And I think one or two consular officers says, we don't give much emphasis to going back on H1. As long as the relationship is okay, in most cases we are fine, but they may also have in isolated cases. So there's a little variance between the way they are processed on H4s or L2s, because they should be looking, as we said, as derivatives of the H1 or L1.
That's right. And the hidden message in this, I think, is clear. And that is, if you're an H1 employer, follow the rules. Make sure you've done your public access file, make sure you've done your postings of your LCA, make sure that you're paying the federally mandated prevailing wage, and make sure if you decide to let an H-1B employee go, that you follow the rules required in order to make sure that you as an employer are not going to get sued for back wage obligations by individuals who are former H-1B employees. There are various steps. The regulations are very clear. If you're not familiar with them, we urge you, of course, to contact a competent legal professional to find out what those rules are. I can't tell you how many calls that we receive from our viewers, from individuals who are seeking services from our firm, who say, if they're H-1B employees, I'm not being paid the wage that was represented on the LCA. It's a big problem. And what we'll do is we'll get the employee and the employer together, and we'll get them on the phone, and we'll say, make sure that you're paying the wage. Because if not, it seems like you're only asking for trouble.
What David is saying also is coming from a concern from many of our clients and our viewers who came here on a visitor visa or a student visa and changed to H1. They don't have a visa stamp on their passport, H1s. And if they are worried, if we go outside of the US and get the visa stamp, to try to get the visa stamp, we could be held up, we could be denied, we could have problems, very reluctant to go. Also, their spouses are going, if they are here, H4s, they are going on a trip and their H4 is expiring, they may have to go get a new H4 stamp. They are worried, shall I send my wife or not? Will she get the visa or not? Will she be able to come back or not? And that was the main reason that we went and talked about these issues.
That's right.
Now, by the way, we have a little time left, but this leads to another thing on a visa waiver interview. Now, as a broadly, they already said that even H4s will be included in the program. For example, if H4 has a previously issued visa and biometrics were taken at that time, and the person just want to renew it, then there may be a visa waiver, although they have not implemented this policy in all the posts. But I'm saying going forward it's possible. They are already, all of them have implemented the visitor visas, and probably they'll be doing shortly student J1 visas, F1 visas, and H4 and a C1 and a D.
Right, but it's sensitive, as we discussed before, Michael, it's sensitive to the consulate. So each consulate has its own rules with regard to which non-immigrant visas. So it's going to depend upon the consulate. And it's clearly part of the policy that's been promulgated by the Department of State that if there is an investigation that's ongoing, then that visa waiver does not work.
Exactly.
It only works if there's no investigation.
No investigation.
So